Society of DC, for those who do not know, is the largest organization located in DC that represents physicians in the DC area. We are happy to have this program, although it is unique and very special. It is part of a larger group of webinar and web-based programs we've been having throughout the year for medical professionals and on different health topics. A couple of housekeeping notes. My name is Robert Hay Jr. I'm the Executive Vice President of the Medical Society of DC, and not the person you're here to hear speaking, but I am here to make sure that this experience is enjoyable for you. For those who are unfamiliar with the Zoom platform, there is a speaker view, which I recommend you click on in your upper right-hand corner of the desktop version, so that way you can see our two speakers today and get the maximum experience. Please keep yourself on mute. Our wonderful MSDC staff, including myself, are going to be making sure people are on mute throughout the formal presentation, so that way we don't have minimal background noise. But please avail yourself of the chat feature, so that way you can ask questions, and we will have a robust Q&A after the formal presentation. Also, please note this session is being recorded, so just be aware of that. And for upcoming MSDC events and past events, which you can access, please visit our website, msdc.org. And it is now my pleasure to turn it over to MSDC past president and medical luminary in the district, Dr. Eliot Sorel, to begin our session today. Thank you, Dr. Sorel.
Thank you very much, Robert. And thank you very much, Pia, for your good work in getting this going. And thank you very much, Sarah, for honoring us to doing this program with us. I'm very pleased to also welcome all of you from around the United States, from California, across the US, from Europe and Asia and Africa who are joining us today for this special webinar. This is really the third in a series that I've had the pleasure of being involved with the Medical Society this year. We started this spring, our first webinar that was devoted to COVID-19, George Floyd, and America's conscience. It was followed by an extraordinary webinar with the former Minister of Health of Switzerland, a friend of mine, Peter Zeltner, that discussed the Swiss healthcare model, and that we will bring into the discussion later today in our discussion, because the Swiss model may have something to offer to us, the United States, because the Swiss have been able to integrate in a very ingenious way both the public sector and the private sector without eliminating anyone from being able to participate, either to have insurance or to offer insurance. It's a very interesting hybrid model that we should discuss maybe in future recommendations to the next administration. And then, of course, this event today that has its roots several years back. Been very pleased and honored to have participated and worked with Professor Rosenbaum when we put together our first amicus for the same subject, the Affordable Care Act, before the United States Supreme Court in 2015. And then now we filed another amicus for this try of eliminating the Affordable Care Act by the Republican Party. We are joined today in this effort by, of course, many colleagues from around the country who contributed to this amicus, and Professor Rosenbaum will elaborate on it. Also want to mention that we would like to keep in mind the fact that United States quest for access to care for all American is more than a century old. There is no other developed economy in the world that has struggled for a century to offer healthcare to all its citizens. It started way back under President Theodore Roosevelt, and we're still not there. The Affordable Care Act that I was privileged to participate in the community meetings that fed into what the act should be way back under the Obama administration was and still is a step in the right direction. It is a progressive piece of legislation, but it is incomplete health policy. It does not cover all Americans, unfortunately. So as President-elect Biden suggested, we need to improve it. And I totally agree, we need to improve it vastly. We need to make sure that all Americans have access to care. And as you can imagine, the pandemic that we are now struggling with has demonstrated in ample ways why it's so important to have access to care. And to have access to care, it's important for all of us to have access to care, because our individual care is dependent on others' care and on population's health. And that kind of education and mentality is not yet fully understood by our citizens. So the challenge to have access to care is huge. The Affordable Care Act, being in the Supreme Court for the third time, we'll discuss today. And we'll be glad to entertain from you your ideas as to how can we achieve access to care for all Americans. It is my pleasure now to introduce my colleague and friend of many years. And she and I started our collaboration about 20 years ago, when together with Congresswoman Morella, we were nibbling at the edges of how to enhance access to care around 2000, 2001. Sara, it's all yours.
Thank you so much, Eliot, and thank you for having me today. It's a real honor to be able to speak to the DC Medical Society, and presumably some of you are eating a sandwich. It's lunchtime here in DC. Others of you from different places may be sipping a morning coffee or eating a late afternoon snack. So I'm going to spend the next 15 minutes or so on the actual case that was argued before the court a few days ago, and sketch out a little bit both what happened in those arguments, what the big takeaways might be, what the consequences of the case might be, when we might expect an opinion, what that opinion might say, which of course is all entirely speculation at this point. Only the court knows the answers to that. But depending on what the court does, what some of the possible follow-on steps might be from the incoming president and from Congress. It's important to know, before I do that, let me just note my thanks to Dr. Sorel and to the other 224 signers of our amicus brief from health policy figures from across the country. We were one of many briefs that went to the court on arguing on behalf of those who defended the law, the states that they came to the law's defense, led by the state of California, the state of New York, and many other states, and DC, of course. And we, of course, presented the court with information. Amicus briefs are designed to educate the court about the critical aspects of the case, and our brief was given who was on our brief, sort of an overview for the court of the important role that the Affordable Care Act has played and the consequences to the population should the act be overturned. And a brief like this is as important for who signs it as for what is said. So this is a critical aspect of litigation at the highest levels, having amicus briefs submitted. And it has been really a wonderful thing to have so many clinicians and researchers and academic figures embrace sort of speaking to the court, which is what the amicus brief allows groups to do. And hopefully it makes a difference. Hopefully the best thing that happens is that you see in an opinion, you see the hat tipped in the direction of one or more amicus briefs. So just a note on the amicus brief process itself. So this case, it's called California versus Texas. So it's literally two behemoth states squaring off against each other, but they are just the stand-in plaintiffs and defendants. This case arose as the result of what was really a very minor change in federal law as part of the tax bill of 2017. The change was designed to revisit the penalty, which is in the Affordable Care Act. There's a penalty for people who can afford to buy insurance and do not. That penalty is in the form of a tax payment. And the first time the law was challenged constitutionally, which was all the way back right after it was enacted, and that led to the first of the great decisions in 2012. The first time the law was challenged, the court said there is nothing unconstitutional about this act, like many laws of Congress. The act is based on Congress's taxing powers. Congress built a tax penalty in designed to sort of incentivize people to buy insurance. The penalty was supposed to roughly represent what it would cost somebody to buy a policy at an affordable rate. The penalty, of course, as you can imagine, was never very popular. In the beginning, when the law was first enacted, the assumption was that a tax penalty would be needed to ensure that enough people signed up for private insurance through the exchange. Of course, DC has an exchange, all states have an exchange. Enough people would sign up to give insurers the kind of robust market that they need to be able to have a viable insurance market. A program like Medicare is social insurance. It covers all of us. Once we start working and into our retirement, we all pay into the system and we get insurance at the other end out of the system. And it's grounded in essentially concepts of social solidarity, which I'm sure are familiar to those of you who think about health policy issues. Then there's a program like Medicaid. Medicaid is a program that functions like insurance, but it's really a public health program. And it's supported with general revenue, and it lives because the general revenue of the United States and the states support it. And it's not insurance in the technical sense, but private insurance requires a large pool of people because it lives on the premiums that people pay. And so you have to have enough people buying the product, and you have to have a heavy mix of healthy people. The concern, of course, in the Affordable Care Act was because insurance for the first time would be available to people who are sick, that we needed an incentive to get healthy people enrolled to make it economically possible for the system to survive. And as the years went by, it became very apparent that actually enough people had enrolled, the system was robust enough because of the subsidies, because of the ease of buying insurance through an exchange. It became apparent to everybody that really the so-called mandate, which is really this tax penalty, was not needed for the law to thrive. And so in 2017, ironically, Congress, which is the Republican Congress, and of course we had a Republican president, took a step that nobody really objected to, which was to drop the penalty down to zero. They didn't repeal the penalty, they didn't get rid of the penalty, they didn't touch the act. In fact, many people went out of their way, many members of Congress went out of their way to give remarks to the effect that they were not touching anybody's insurance. They were simply getting rid of the penalty. So you could make whatever choice you want to make about buying insurance or not buying insurance without fear that if you didn't buy insurance, you would pay. So the law is on the books, but the penalty is right now at zero. Immediately after the tax law was signed, a group of Republican attorneys general, the same Republican attorneys general pretty much who brought the lawsuit back in 2012, went to court and put together a sort of an astonishing argument. They were joined by two individual plaintiffs. So you had states and you had two individuals. And their argument was essentially that by repealing the penalty, by dropping the penalty to zero, Congress had eliminated the constitutional basis for the law, that a penalty of zero is not a tax any longer. And because the law no longer contains a constitutional tax, the rest of the law can no longer survive. It's known as inseverability, that everything in the original law was so intimately bound up with this so-called mandate. They kept calling it a mandate, even though it's not a mandate. Everything's so bound up in the so-called mandate that if the mandate was no longer formed the constitutional basis for the law, Congress, of course, must have a constitutional basis on which to act, that the law could not survive. It all had to be repealed. The trial court, very, very conservative judge in Fort Worth, Texas, agreed. And the case then moved to the Court of Appeals. The judge in Fort Worth entered his decision just as President Trump was taking office. And lo and behold, the government, which of course had been defending the law when Obama was president, suddenly said, oh, we support a repeal either entirely or at least big chunks of the law. And they entered the case on behalf of these, the opponents, a big group of states headed by California, New York, all the Massachusetts states that you would imagine, sort of the blue states, intervened in the case in order to defend the law. And when the case got up to the Fifth Circuit Court of Appeals, the Fifth Circuit said, yep, the law no longer has a constitutional basis. Zeroing out the mandate means there's no more constitutional basis for the law. And they wanted the case actually to go back to the trial court for some more work on this question of severability. Could the rest of the law still stand? The Supreme Court had enough. Supreme Court, imagine a hand coming down and grabbing the case and saying, enough is enough. We're going to take a look at this case, which of course the court has every right to do. And they scheduled the oral arguments for what they thought would be the nice, calm post-election period, middle of November. And that's what happened on Monday. We had this oral argument, which by then, of course, is happening in the middle of a pandemic, in the middle of a historical presidential election, with the winner being somebody who got more votes than any person who ran in American history. The winner happening to be, of course, the vice president, who was Obama's partner during the Obama administration, and the current president appearing to have lost. So you could not ask for more turmoil. If a screenwriter came in with a screenplay for a movie that attempted to sort of set the stage for this oral argument, the person would be thrown out as, you know, having fabricated a crazy story. So the argument then unfolded. It unfolded over 90 minutes. And in these kinds of cases, in this case, there are three huge issues that were the subject of the arguments, both the defenders of the overturning the entire law position and the defenders of the Affordable Care Act itself. And those three issues are: one, what's known as standing; two, whether in fact a tax that is set to zero somehow becomes an unconstitutional tax; and three, this issue of severability. That is, if the tax turns out to be unconstitutional now, can the rest of the law be saved? Could the court just strike down, say, you know, there's no more tax, but there are plenty of bases for this law to remain on the books, and it's up to Congress to get rid of the law. So I will start with the color commentary. My color commentary, and my color commentary here is, you could tell the court was not a happy camper that it was back having to hear yet a third. It turns out there was another case in 2015, the one that Dr. Sorel referenced. So this is a third time through for the court. And the court made that, the court, of course, is unfailingly polite, but the court made its displeasure very clear. At one point, the Chief Justice Roberts, who has saved the law twice now, turned to the Texas solicitor and said, "You have simply come here asking us to do what only Congress can do, that is repeal a law. Basically, you're here because you concocted a lawsuit to try and get rid of the Affordable Care Act when your efforts in the summer of 2017 to repeal the act failed." He said it more politely than I'm saying it to you, but not a lot more politely. So that was one clue. Another clue as to sort of where the court's mind was in all of this was that it became pretty evident. I don't know of anybody who reached a different conclusion, that even if they found that the plaintiffs had standing, that is, that they had the kind of legal injury that allows people to go to court. You can complain all you want about law, but in order to go to court, you have to have something called standing. You have to have a legal injury. So even if they had standing, which was the subject of great debate, and even if the zeroing out of a tax penalty meant that it is no longer a tax, basically, the Chief Justice and Justice Kavanaugh showed their cards. They made quite clear that they were not in any mood to bring down the entire Affordable Care Act based on the arguments in front of them. A number of the legal experts who've written commentary on the argument since it was presented think that it's very possible that the court's just going to toss the whole case. That the court's going to say, you know what, the individuals who are the plaintiffs don't have standing, and the states don't have standing. You're both here with your political agendas, your political complaints, but the only thing that the 2017 tax law did was to give individuals more flexibility and more choice. There is no more obligation on your part to buy insurance. You are free to make whatever decision you want because there is no penalty if you forego insurance. So you don't have a legal injury. And in the case of the states claimed that their legal injury would arise if the law were to be found constitutional and they were forced to continue doing the things that the law requires them to do. And it will be of interest, I'm sure, to all of you that the core injury that the lead plaintiff, which is the state of Texas, the lead opponent of the law, pointed to as why this law is such an injury to the state of Texas is that it has been required to insure more people under the Medicaid program. It's a non-expansion state, but there were other changes in Medicaid that make the program easier to enroll in. So they're injured because they've had to give Medicaid to more residents who are poor and uninsured. And they're injured because they have to send notices out to people each year confirming if they have insurance. You need, I'm sure those of you who do your taxes know, you have to file a sort of a confirming note to the IRS regarding the fact that you have insurance. So the state has to send notes out to many people about the fact that that they have insurance coverage through the state, and they had to give Medicaid coverage. So these were the injuries, and those injuries are injuries really only if the law survives, and so they're sort of speculative. If the issue is whether the law is constitutional, you don't get to their injuries until down the road argument. So standing is a possibility. The court could say nobody has the right at this point to come to court and challenge the law. On the constitutional argument that the tax as a zero penalty is not a tax any longer, there was a fair amount of pushback from some of the justices, and the most interesting example of that came when Justice Sotomayor posed a question to one of the lawyers arguing against the survival of the Affordable Care Act, and said, look, what if Congress passed a law that said the tax penalty is set at this level, but that if plenty of people buy insurance, then we drop the penalty down to zero, because nobody needs to pay a penalty anymore to keep the insurance market viable. And we only go back to a penalty worth something if we start losing people from the risk pool, and we got to sort of start turning up the flame, thinking of it as turning up a flame, turning down a flame. Would that be constitutional? And the answer was yes. So the question, of course, arises when, if Congress turns the flame down to zero, does that mean that there's no longer a tax? And the answer is, well, maybe there is. The tax just happens to be zero right now, and Congress could always turn the flame back up. So that was very interesting. And the third issue was the severability issue. And there, what severability comes down to is the intent of Congress. And interestingly, the people opposed to the law kept arguing about what Congress intended in 2010. Well, in 2010, they made very clear that this law could not survive without a mandate, referring to it as a mandate, couldn't survive. So if the mandate is no longer constitutional, then the law must fall. And the Chief Justice was very tough. He said, yes, but the point is that law is more organic than that. That by 2017, we've experienced a vast sea change in our thinking. We could see that the law survived. And there's all this evidence from Congress in 2017 that when they dropped the penalty to zero, nobody intended that the law fall. And if they had intended that the law be repealed, why didn't they repeal it? And what you're pointing to as far as legislation is concerned is ancient history. And whatever the 2010 Congress thought really is a very different issue from what confronts the court today. Should we, based on what Congress did in 2017, impute intention all the way back to 2010? Very different Congress. So that's sort of the summary of the argument, and it's important to to stop and think for just a couple of minutes before we go to questions and comments. It's important to think about what might happen. So the court could surprise us all and announce that the plaintiffs, the challengers, have the standing, the so-called mandate is unconstitutional, and the law is inseverable in its entirety, and it's gone. Okay. That would be probably the most unlikely result, but it would immediately throw the country into great turmoil. The court might, the Solicitor General arguing for the United States said, well, you could overturn the law, but then what's called stay your order, to let Congress sort of step in and fix things, and without costing everybody insurance. But the decision would be understood as wiping out the Affordable Care Act. It would set off an absolute panic in the country in the middle of a COVID pandemic. 20 million people's coverage is at stake. The pre-existing condition protections, the market protections for the rest of us, hundreds of millions of people benefit from those protections, the coverage for young adults. Just think about what would be gone. All the coverage that the law provides for free immunizations, gone. And Congress would then be in a mad scramble with President Biden to come up with a replacement. And so chaos would ensue, which makes that result the least likely. Courts are their own creatures, but they don't live in a bubble. They certainly understand what the impact of such a far-reaching decision would be. They could strike down the mandate as unconstitutional and simply throw out certain pieces of the law, the so-called market reforms, the prohibition on pre-existing condition exclusions, rules about community rating, rules about marketing and sales, rules about not discriminating in how you price the insurance product. They could do that, but that's probably pretty unlikely that they would literally sit and pick and choose, especially since the court made clear that whatever Congress thought about the relationship between the penalty and market reforms in 2010 no longer matters. But that would force Congress and the president back to the table if they were to do a partial ruling on inseverability. The case could be thrown out on standing for sure. That's the end of that. No ruling on anything. They just say nobody had standing to bring this case. Let's go back to square one. It's as if the case never happened. The most likely result, I think, people would conclude, certainly I do, is that the court, whatever it does on standing, whatever it does on the mandate, lets the law survive. And then there is no action forcing event in Congress. The president and Congress will continue to debate ways in which the law might be improved or altered. And those, of course, are expected to be very complicated arguments because of the sort of the split in federal powers that seems to have come out of this election. But it would leave things status quo. We'd have the Affordable Care Act, and the issue would be, do we strengthen it or do we water it down? But that's, that's the politics of the moment. There are certain things the Biden administration might do on its own administratively to strengthen the Affordable Care Act and how it's performing during a pandemic. And maybe we can talk about those things a little bit in the Q&A period. But that's sort of the case in a nutshell.
Thank you very much, Sara, for a intelligible translation for mostly health practitioners and researchers interested in the policy of health in the United States. And it is really a unique case of a developed economy with no access to care for all its citizens, so urgently needed, especially in a pandemic and generally speaking. The floor is open for comments and questions, please. Anyone has any question or comment? Sara, I have a question that
Yes.
is not part of this debate, the current case, but one of the situations in the United States, which is not so in the other developed economies that cover their citizens, is that our insurance plans are employment tied. Is the Affordable Care Act, if you sign for the Affordable Care Act, is tied to the employment or not?
Well, the Affordable Care Act essentially preserves employee benefits as a core feature of the American insurance system. You're absolutely right. And they're actually, for the largest employers, the Affordable Care Act did include penalties for very large employers that do not provide what's called minimum essential coverage for their employees. But the Affordable Care Act was really designed to create other pathways to insurance. And those other pathways were, of course, a dramatic expansion of the Medicaid program, which is in effect here in DC, and of course it's in effect in Virginia and Maryland as well. Virginia was sort of late to the party, but Virginia is a Medicaid expansion state. And the expansion is now in effect in all the 12 states. And then, of course, the law very famously created health insurance exchanges, like we find in DC, Maryland, and Virginia, where you can go and you receive tax subsidies and you have the ability to buy an individual policy. If you don't have insurance through work and your income is too high for Medicaid. And the thinking was that the country essentially needs some off-ramps because of what's happened to us over the past really 30 or 40 years in the United States is that, probably not for those of us on this call, but for so many Americans, the employment-based insurance system has crumbled away. I just finished an article with a couple of colleagues on children's insurance. And today in the United States, a minority of children, less than 50%, have families that can get them employment-based coverage. Medicaid and its companion program, the Children's Health Insurance Program, covers 40% of all children in the United States. So it's really an astonishing thing when you think about it, that what we call mainstream insurance doesn't even reach half the children in the US. And as far as adults go, only about 6 in 10, maybe slightly more than 6 in 10 working age adults have employment-based insurance. A lot of them don't even get an offer, and many who get an offer can't afford to buy it. So what's sort of happening to us as a country is that the employment-based insurance system is eroding in front of our eyes. There are advocates for sort of pushing this process along faster. Of course, Senator Sanders and Representative Jayapal, who are great advocates for a single payer system, say, let's end this pain now. Let's simply, essentially, recreate the Medicare program and have it be universal the way, say, Canada has a universal public insurance program. There are other people, and of course, President-elect Biden is one of them, who say, no. As long as we have an employment-based system that people really like, we want to preserve it, but we should be creating a stronger public insurance system to run alongside for people who either don't have employment coverage or would prefer to buy their own individual policy. And let's make it easier for people to make that kind of a choice. And then there are people who, putting aside what's called the public option, say, well, let's keep private insurance, but let's just give more people the same tax subsidies that we created in 2010. So let's keep a big individual private insurance market and give people more ways to afford to buy it. So you sort of see this continuum of ideas. Interestingly, people who are very conservative would tend to agree that the current system doesn't work well, but in their view, that the way to deal with all of this is to replace the whole mess. Employment benefits, a public program over here, another public program over here, give everybody essentially the means to go buy an individual policy and let them go on the open market and buy an individual policy. So a completely deregulated system in which the purchase of insurance would happen between one individual and one insurance company. That is maybe the most dramatic version of where conservative thinking is. So a wide range of solutions, but probably a not uncommon recognition that our current system as we've known it really doesn't work very well for a lot of Americans.
Thank you very much. Thank you also for highlighting that the children are the population at highest risk of not being insured. They're most underserved, which is not the case in other developed economies. We have a question from one of our colleagues, Veronica Slutsky. How these decisions, whatever they may come to be, affect mental health coverage?
Well, of course, the Affordable Care Act itself paid a fair amount of attention to mental health coverage. I'm sure not as much as people who are experts in mental health would say. And of course, it certainly could be strengthened. But for people who buy individual policies through the exchange, in fact, mental health services are one of what's known as the essential health benefits. So there is a recognition in the Affordable Care Act of the importance of coverage for the cluster of conditions that we sort of commonly refer to as mental health conditions. There's also in that broad umbrella, it is understood that substance use disorder is also an essential benefit treatment for substance use disorder. And so if the act were to fall and the definition of essential health benefits were to go away, then to the extent that there was any individual market left at all, first of all, only healthy people would be able to buy an individual policy. And second of all, sellers of individual policies likely would avoid any coverage for anything that's serious and chronic and that costs a fair amount of money, or they would offer policies that are what we call junk insurance. That's not a legal term of art, but it's an accurate term of art. That says, oh yeah, well, we'll cover you, but your deductible is $25,000. So essentially gutting the gains made under the Affordable Care Act. The other thing I should note is that the mental health parity law predates the Affordable Care Act by a couple of years. The original parity statute was enacted in 1996. It was strengthened in 2008, and it's proved to be a law with some teeth to it in terms of stopping health insurers that tend to discriminate against people with mental illness in how they make coverage decisions. It's curbed some of the worst practices. I would say that most of us who know anything about this particular cluster of conditions and insurance would say that coverage doesn't do nearly what it needs to do, but it's definitely a feature of the ACA.
Thank you very much. What about the issue, health is being treated most in most policy discussion as it's looked at as an expense, health coverage, while defense allocations are an investment. Isn't health also an investment, and how can we craft it into a law to make it so?
Yeah, so it's a good question, and I don't think the answer to that is a legal answer. I think the answer is the political answer, although there is a technical aspect to this. So, the politics of health reform are and have always been. It's a cultural issue, it's a social issue, it's a political issue. How do you make Americans embrace the kind of solidarity we need to have a universal program that covers us all, as fair, makes healthcare fair, equally accessible based on need, equitable in how the system operates, and efficient enough in operation to make it truly a great investment. And of course, one of the arguments is we all need healthcare. A lot of things go into being a healthy person, and of course, as many public health experts tell us, healthcare really plays a small role. But I will tell you, when you're sick, you need healthcare, and there are certain forms of healthcare, obviously, that are essential to maintaining health. The more technical answer, it's a political crapshoot to decide when the country is going to come to its senses. But the more technical answer is that the process by which Congress budgets for expenditures, federal expenditures, is a process that does not favor long-term investment. It is very hard to get the Congressional Budget Office, which works under incredible constraints, to recognize that it is an investment when we talk about healthcare that will pay off. They want to know what it's going to cost this year and what are the offsets for this year. And so, the point of being healthy is a lifelong investment in humanity. And that's not the way that CBO, as they call it, scores legislation. So.
Thank you, Sara. I have a very interesting question from Laka Negasa. With thanks to you, Sara. The question is, in your opinion, where does the quotes distaste, end quotes, for the ACA stem from? Why is making it better or working on parts of the law to make it better not an option? Do you think that is too far-fetched?
No, your question is sort of one of those questions that so many of us have asked ourselves, if not each other, over the years. This is a pure political play. When the Obama administration came forward with the blueprint for the Affordable Care Act, and was joined, of course, by House and Senate leadership, they literally turned to a proposal from the Heritage Foundation dating back to 1993. For those of you not familiar with the Heritage Foundation is an extremely conservative think tank. And they came up with a model that requires everybody to have insurance and gives them refundable tax credits to go buy insurance. Now, the Heritage Foundation would have taken it a step further and had that model as a substitute for all of us. But the point is that if you look at the left side of the Democratic spectrum, the left part of the spectrum, the left found the Affordable Care Act proposal anathema, precisely because it, assumed this very atomized market for insurance. It was not social insurance. It was not solidarity. It was not an investment on behalf of all of us. It was sort of giving everybody some script to go off and buy insurance coverage. And that has been the paradox for a decade now, which is how a law that is so purposely designed to be a conservative response to the problem of uninsurance, how could a law like that be so opposed? And I think, needless to say, you could probably fill a library with books and articles written on this very subject, what political scientists tell us, what sociologists tell us, and I don't think there's a better explanation than the sheer, complete hatred of President Obama and a desire to undo everything he did, everything he achieved. And the law has endured, really, among my legal friends, my lawyer friends, those of us who study and work in law and think about law from an academic perspective, we cannot think of a situation like this, where a law that is such a landmark has endured so much for so long. And there really is very little explanation of this other than just a visceral hatred of the person whose name has become synonymous with the law. Congress sort of appeared to back off in 2017. The Trump administration itself, using its administrative powers, has continued to go after the law. If this law were to be wiped off the face of the earth by the Supreme Court, the Republican leadership would probably go out of its way to make sure that it could not be established as law.
Thank you, Sarah. There is an interesting question. I'll want to preface it. Your data on children being least or highest at risk, that projects for future the risk for illness being less covered, enhances the chances of the burden of disease being catastrophic in decades to come. So it's not a very wise policy, obviously, not to invest in children's health and having them as the most at-risk population. The question that colleague Clint Peebles is asking, what do you anticipate to be the future of Medicare expansion? And do you think the Biden plan, is there a Biden plan to address this?
I'm sorry, Medicare. I was just looking at
Medicaid
expansion.
Yeah.
So I think that President Biden can be expected to be quite interested in how to make Medicaid work better. And there are a number of options for making the program work better. Of course, for children, the interesting thing, and I should note that along with Jim Perrin, who's the lead author, who some of you may know, who's a renowned pediatrician in Boston, and my friend and colleague Genevieve Kenny from from the Urban Institute. The three of us have a piece coming out in the New England Journal of Medicine in the coming weeks about how to improve Medicaid for children. So we're clearly all sort of thinking the same way. And what we have recommended are several steps that would require legislative intervention, not just better rulemakings. But the core of our recommendation is that you need to have a federal standard bringing Medicaid payment rates for physician services up to Medicare rates, so that there would not continue to be discrimination against children on Medicaid. Although I must say, of all the populations who depend on Medicaid, children have really the most remarkable access to care. That the pediatric care world embraces children to an extraordinary degree. And for that reason, because Medicaid offers such comprehensive coverage with no cost sharing, children on Medicaid actually fare as well in terms of access to services, medical services as children with private insurance. But they, of course, need so much more because they're so poor. But of all the ways to improve Medicaid, a couple of the big ones would be to fix the problem of rates, and to have all children on what we call an annual enrollment period. So there's no risk of interrupted coverage during the year.
Now, this is a crystal ball question. I think it's much touted and promised. Do you know, question from Eva Perdal. Do we know if there is even a skeleton of a GOP replacement plan?
Well, certainly if we use the past few months' experience in the election to guide us, then we know that there's no GOP replacement plan. They didn't offer one as part of their platform. The president has, of course, not been able to articulate one. You know, it would fall to, if in fact the Republicans hold the Senate, it would fall to a Republican-controlled Senate to come up with a replacement plan. And we saw their idea of a replacement plan back in 2017. That was the effort to repeal the Affordable Care Act, with, of course, a very, very famous moment that I'm sure we all lived through of Senator McCain going thumbs down. And that plan, which was a Republican plan, resulted in the disinsurance of over 20 million people. So they clearly understand that they have to do better. And I assume one of the reasons why we haven't seen a fully articulated replacement plan is because, quite frankly, their own members have no particular interest in seeing universal coverage. I mean, you could imagine an approach, and I'm not a fan of this approach, but an approach where everybody is given enough money to buy individual or family coverage. And there's, you just go shopping the way you would shop for anything at a store, and you go buy a policy. And it's not a very good way to run a system unless you're willing to very heavily regulate insurers. But it's essentially the heritage model, and that's where conservatives were 30 years ago. Now, I would say there is no consensus that government should intervene at all on this problem. And that's why I think we don't have a plan, because the party is not in a position now in which it can endorse a solution to a problem that involves government in any form.
I think one of the related issues, Sarah, I have a kind of a reflection kind of thought. One of the concerns that I have is the stress test that the pandemic has brought to bear on the health system. Mm-hmm. That this health system has been put to an enormous and unprecedented stress.
Right.
And particularly affecting all people, and especially the frontline workers. Mm-hmm. And I think all these issues are related. I mean, not having insurance to take care of your health early before it gets too complex and complicated, increases the chances of more severe illness, increases the stress on the system, on the health workforce, and undermines its performance. Any thoughts along those lines regarding how this could be fed into policy and health reform?
Well, I think it goes back to your earlier point that to do health reform properly, you need to take a step back and say what is good for society, what is a social investment, and you, like I would say, like other very intelligent people, think in terms of social welfare policy. What makes sense for a nation to spend money on from a long-term gain perspective? And look, the proof is in the pudding here. Every other wealthy nation guarantees universality, and we know from many studies that there are a number of ways to do it. You can have a single payer system. You can have a much more system tied to individual subsidies and individual purchasing decisions. You can have a mix of coverage approaches. There are so many ways to do this. And the problem with the United States, I always think, is, we've got to just pick a system. And the good thing about the Affordable Care Act, putting aside the sort of underlying structural merits, is we picked a model. We got it through an unbelievable legislative battle. If fully implemented, and there were things that the Supreme Court did in its 2012 decision to sort of frustrate that, mostly making Medicaid optional. But if fully implemented, the Affordable Care Act was projected to reach 94% of the population. That was the original projection. We still would have needed reforms, as it turns out, but those reforms are pretty clear. We need a public option with very, very affordable subsidies would probably get us, back on track to get to 94, 95% of the population insured. But the biggest resistance, obviously, in this country, the other great issue that is so tearing this country apart is immigration. And we have taken such a difficult stance as a nation around whether immigrants should have access to affordable insurance, particularly if they are not, they're not here under a legal authorization. So, but that's a problem in other nations too. My only point is that we picked an approach after one of the greatest legislative battles in the history of the country. The law was enacted. And so, having done the work I do for about 45 years now, I would say, let's be practical and let's strengthen the Affordable Care Act in a variety of important ways rather than just simply setting it aside. But that, again, takes a belief in investing in the population and spending money.
Sara, as I've joined you in the prior Amici, I'll join you in this next battle to make this part of the Biden administration initiative.
Good.
And thank you very much for your illuminating presentation, very thoughtful and comprehensive reply to the questions. It's been a privilege to have you with us. God bless you with good health and continued long life, creative, and contributing to the next policies in the United States. Thank you
for having me. Bye.
Bye-bye. Thank you all for joining us around the world and the US. Thank you. All the best. Good health.
Thank you.